facility, and finally disposed of as low-level waste in a solid form. And then the waste is shipped to waste control specialists in Texas for storage. Next slide. So the US Department of Energy started by using 3 gallons of waste as a test. And now they're hoping to scale up to 2,000 gallons and ultimately want to treat 500,000 gallons of tank waste through the TBI. So the TBI really hinges on Energy's waste incidental to reprocessing determination, or WIR, whereby high-level waste is reclassified as mixed low-level waste, changing the disposal requirements. So the bottom line really is that the testbed initiative at Hanford will determine the future of radioactive tank waste. And so on August 17th of 2021, Energy quietly released the draft environmental assessment for the testbed initiative without notifying the public and without providing an opportunity for a public hearing or comment period. So a select group, including the Washington Department of Ecology and the Confederated Tribes and Bands of the Yakama Nation, were invited to comment on the EA, and Hanford Challenge offered their own unsolicited public comments. Many of you probably signed Riverkeeper's petition asking for the opportunity for public participation on this important issue. And now coming up, we do have a public comment period. Energy is planning on opening a 90-day public comment period on its plan to use the Draft WIR evaluation to analyze whether pre-treated waste from a tank, SY-101, may be managed as mixed low-level radioactive waste and disposed of off-site. So our panelists today will be discussing the Draft WIR, the TBI, the reclassification of waste, and implications on and off-site of Energy's testbed initiative. So joining us today, we have Caroline Cress, an Assistant Attorney General in the Ecology Division of the Washington State Attorney General's Office. Caroline has represented the Department of Ecology's nuclear waste program in its regulatory oversight at the Hanford Nuclear Site. We are also joined by McClure Tosch, the Natural Resource Injury Assessment Coordinator for the Yakama Nation Environmental Restoration and Waste Management Program. McClure has worked for the Yakama Nation for over 11 years and has worked on priority cleanup sites up and down the Columbia River. And our final panelist is Nikolas Peterson, the Deputy and Legal Director at Hanford Challenge. Nikolas has worked at Hanford Challenge for almost a decade and has provided legal representation to dozens of whistleblowers at the Hanford Nuclear Site. Who better to prepare us for the upcoming comment period than Caroline, McClure, and Nikolas, all of whom provided solicited and unsolicited comments on Energy's EA for the TBI. So please make sure to send in your questions via the chat function, as we will have time at the end of the presentation for a short Q&A. And Caroline, if you would like to start, I will pass it over to you.
Great, thanks, Simone. Like Simone said, my name is Caroline Cress. I work for the Washington Attorney General's Office and the Department of Ecology, which is the regulator of the Hanford site under RCRA is my client. And I've been the co-lead attorney for Ecology's nuclear waste program for about 5 years. I do want to start with a disclaimer that this presentation and what I'm going to say today largely represents my personal opinions, which are based on my own observations and experience, not necessarily giving a formal opinion today on behalf of the Attorney General's Office or the Department of Ecology. But what I am going to do is walk through basically what a WIR determination is and how it fits into the regulatory framework that governs Hanford cleanup, and specifically the Hanford Tank Waste Mission. So I'm going to go over kind of the basics of like what, why, and how of WIR determinations. So at a high level, the what is a WIR determination basically is a nuclear waste reclassification decision. And it's made by Energy unilaterally under its self-regulatory authority under the Atomic Energy Act. At Hanford, the WIR determination process is governed by internal energy orders and guidance documents that it's issued. So specifically, DOE Order 435.1, and then there's an implementation manual and guidance that go along with that. And as part of this process, Energy consults with the Nuclear Regulatory Commission, the NRC, but isn't necessarily subject to their formal approval. And I think it's important to state here at the outset that the state of Washington does not have regulatory authority under the AEA so it does not regulate the WIR process itself. We will basically be commenting on this WIR evaluation along with you all as a member of the public. But I will get to later in my remarks the role that the state does play in regulating under RCRA and how these things interact. But before we get to that, I'm going to start out with, so why is a WIR determination even necessary? Basically, the purpose of it is to get out of certain legal requirements that would otherwise apply to the disposal of high-level radioactive waste. And the reason that this is important to NRG is because the waste in the tanks, the single shell tanks and double shell tanks, is high-level waste by definition, according to the definition that's in the Nuclear Waste Policy Act. And the NRC has looked at this in the past. I think they found that 2 of those tanks could fairly be classified as something other than high-level waste just based on the strict definition of where the waste came from. And I will note also the Atomic Energy Act incorporates by reference this definition that's in the Nuclear Waste Policy Act. So that's on your screen right there. That's the statutory definition. You'll see that it's source-based. So it basically says there's this stream of waste that was generated by the reprocessing of spent nuclear fuel. And when this was enacted into statute, Congress basically made the determination that all of the waste that was generated by that process is highly radioactive and is just by definition high-level waste. And then there's another way that something can be high-level waste, which is if the Nuclear Regulatory Commission, the NRC, defines by rule that another waste stream is high-level waste. So the second part of that statutory definition isn't really at play here. I did underline a couple of things because I want to come back to how energy has incorporated this definition into Order 435.1, but we really are focused on A, that first part of the definition here. So the reason that this matters is because the Nuclear Waste Policy Act requires that any high-level waste be disposed of in a deep geologic repository. And that, at the end of the day, is very expensive to do, and there's no operational deep geologic repository available yet. By law, under the Nuclear Waste Policy Act, it is supposed to be at Yucca Mountain, but that licensing process has been stalled for a number of years. So there's a lot of uncertainty as to where that location will be and when it will be available. But it is also, I think, widely recognized that disposal in that kind of location is fairly expensive because of the engineering that has to go into building that facility. There is another reason that the WIR process is so important. So we'll go to the next slide, which is an excerpt from the Energy Reorganization Act of 1974. So in 1974, Congress passed this law that amended the Atomic Energy Act, and it also, what formerly was the NRC and DOE was called at the time the Atomic Energy Commission, the AEC. So the Energy Reorganization Act basically turned the AEC into 2 separate agencies, one of which is the U.S. Nuclear Regulatory Commission, the NRC, and the other was the Energy Research and Development Administration, ERDA. And then in 1977, ERDA actually became NRG. So the Energy Reorganization Act essentially took the AEC's functions and split them into the NRC and what later became DOE. It placed most of the licensing and regulatory functions in the NRC and then gave to ERDA, or DOE, the research and development functions. It also gave NRG basically a self-regulatory authority over defense waste. So essentially high-level waste that were generated for the purpose of creating our nation's nuclear arsenal. The reason that this comes into play here is because there's a Section 202 of the Energy Reorganization Act basically has a few narrow carve-outs where NRC retains licensing authority over the Department of Energy's facilities or its waste. One of those narrow carve-outs you'll see on your screen there is DOE facilities that are authorized for the express purpose of subsequent long-term storage of high-level radioactive waste generated by DOE. So, and subsequent long-term storage has also been interpreted to include disposal. So any disposal sites of NRG's high-level waste or long-term storage, which is generally like more than 20 years, is technically subject to NRC licensing under the Energy Reorganization Act. So in order to be able to dispose of certain fractions of the tank waste from Hanford in a near surface landfill, and without NRC licensing, we have to go through this WIR process to demonstrate that that waste stream is not high-level waste and can be managed as something else under the Atomic Energy Act. So that's the context in which we're operating and kind of the purpose of needing a WIR determination. So how do we actually go about making that determination that something is not high-level waste? And like I said, the state does not have a direct regulatory role here, but the criteria that are in 435.1, and let's go to the next slide real quick. So this is an excerpt from 435.1, the manual that implements the order. It sets forth the definition of high-level waste from the Nuclear Waste Policy Act. Although, strangely, it omits the part about the commission, the NRC, defining by rule this other stream, which is a slight oddity of 435.1. But like I said, that's not the part of the definition we're relying on here. So 435.1 sets up this waste incidental to reprocessing determination, which is basically you take a certain waste stream that would otherwise be high-level waste, and you demonstrate through certain criteria that's supported by a performance assessment that it can be safely managed as mixed low-level waste. So let's go to the next slide. So these are the criteria that govern this process under 435.1. These criteria actually came about as a result of some consultation between the state and energy and NRC in the 1990s. So where this started was a 1990 petition for rulemaking that the states of Washington and Oregon filed with NRC to essentially clarify the definition of high-level waste and set up a process or a procedure and substantive criteria that could be used to determine when Hanford tank waste is and is not high-level waste. In 1993, the NRC denied that rulemaking petition and basically found that the existing definition is sufficient, that it essentially wouldn't be that cost efficient to go through a whole rulemaking process to basically to resolve an issue that is so, it's not very widespread. There are only a few sites around the country that have high-level waste. And so the NRC said, what you already have to work with, it should be sufficient, but here we're gonna go ahead and set some markers for what we think you could use this definition for in terms of finding that some waste streams are incidental and thus not subject to disposal restrictions for high-level waste. So it created these criteria in a 1993 letter that was shared with energy, and then there were some meetings back and forth between energy and NRC over the following 4 years, and in 1997, NRC sent DOE a letter that represented a provisional agreement. We call it a Provisional Weir, that basically said if energy follows its current plans and meets these 3 criteria that we've laid out, then we agree that that waste stream, which we will call low activity waste, after it goes through pretreatment, is likely to be incidental waste in accordance with those criteria. But NRC also basically said, you know, we're telling you now that we think you can use these criteria, but if you change your plans at all, you're going to have to come back to us and make sure that we're still on the right track here and that you're not disposing of high-level waste outside of a license. So in 1999, Energy issued this order and manual, basically incorporating almost verbatim the criteria that the NRC established in the 1990s, with the exception of what I've put a little red arrow there too, which is an alternative requirements provision that kind of leaves the door open for Energy to set its own standards and kind of say, you know, it's not high-level waste if we say it's not high-level waste, which is very similar to what they've subsequently done with their high-level waste interpretation. But again, that is not an issue in this particular WIR determination as far as we are aware at this point. We understand that they'll be using the 3 criteria and not relying on alternative requirements. But I will call out that as you're reviewing this WIR determination or the evaluation that will eventually be a determination, keep your eye out for whether they are actually meeting these criteria or where they might be relying on alternative requirements. And the important thing there is there was a lawsuit in between 2004 and, when was that? 2003 and 2004, where this order was actually vacated by a district court in Idaho, federal district court, as being outside of Energy's statutory authority to define what high-level waste is, especially if it's in conflict with the definition under the Nuclear Waste Policy Act. And the court's decision in finding that conflict was really based on this alternative requirements provision that Energy doesn't have the authority to kind of make up its own framework here. That decision itself was vacated by the Ninth Circuit because they found that the case wasn't ripe yet, because Energy hadn't actually used this order and these criteria to reclassify a specific waste stream. So the court basically said, let's wait and see, let's let Energy actually go through this process. And if it turns out that they're using these criteria or the alternative requirements provision in a way that is in conflict with the Nuclear Waste Policy Act, at that point, there might be a ripe case that you can come back with. So as of right now, this order is in effect, it's legal, but it does have this kind of shroud of doubt over the alternative requirements provision. So just be on the lookout for that when you're reviewing and commenting. And then let's go to the next slide. Oh, so this, I will also note that Energy recently updated Order 435.1 and the manual that goes with it to incorporate its new interpretive rule that interprets the Nuclear Waste Policy Act's definition of high-level waste. We understand that it will not be relying on this for purposes of this WIR evaluation, but another thing to just keep an eye out for, if they are not meeting those 3 robust criteria that are set forth on the previous slide and that the NRC established, then there may be some legal issues to comment on there. All right, next slide. So the reason I'm talking to you on behalf of the state is because the state does have a role in the cleanup, although we don't have a decision-making role under the Atomic Energy Act. I made up this diagram to show how complicated the regulatory framework is at Hanford. You've got a lot of different laws that are in play, both federal and state, and they all apply in fairly similar but different ways to basically the same waste stream. So what we're looking at here in this circle is basically the overlap between the big blue circle, which is the Hazardous Waste Management Act, which is the state implements in lieu of RCRA in Washington, and the red circle, which is Atomic Energy Act materials. And let's go to so mixed waste is in the space in that Venn diagram between the two. And so it's subject to both regulatory frameworks simultaneously. So let's go to the next slide. So just as a very preliminary matter, and I won't stay on this very long, but I can answer any questions you might have about it. We've got this one waste form that is subject under RCRA. The hazardous component of the waste is subject to RCRA and the Hazardous Waste Management Act. The radionuclide component is subject to the AEA, which is governed by Energy's orders under the AEA. And this is pretty settled law that mixed waste is subject to both at the same time. But when you actually get to implementing that general principle, it becomes more complicated. So let's go to the next slide. There are a couple of principles under RCRA that are important to note. One is, this comes from the Federal Facility Compliance Act of 1992, which amended RCRA to make it clear that the federal government, including its agencies, are subject to RCRA and any state laws about hazardous waste management, just like anybody else is, in the same manner and to the same extent as any other person. So just because it's the federal government or just because this waste is also subject to another regime does not exempt it from RCRA. Let's go to the next slide. This is a provision that kicks in the event that so like I said, this waste form is regulated simultaneously under RCRA and the AEA. If a specific requirement of RCRA conflicts with a specific requirement of the AEA, then RCRA yields to the AEA. But this provision is also very clear that the state has authority to regulate the entire waste form unless it's inconsistent. So basically, in order to have one of these conflicts, you have to have an irreconcilable conflict between the two. If you're asking, or if you're regulating the waste under RCRA in such a way that makes it more expensive or makes what you're already doing under the AEA more expensive or more complicated, that's not an irreconcilable conflict. That might be a complication that you have to work through, but it's not a trump card, essentially. So let's go to the next slide. So this is why it matters that this waste is also subject to RCRA. RCRA, the federal regulations under the Land Disposal Restrictions Program, has a treatment standard for high-level waste. It isn't necessarily tied to the nuclear waste policy definition. It doesn't incorporate it by reference, but it applies to a waste form that has certain characteristic waste codes assigned to it, which are on the Part A's for the SST and DST systems. And this waste was generated during the reprocessing of spent fuel. So this treatment standard has attached to the tank waste already. And this is an important distinction between RCRA and AEA. So under the AEA, energy can basically classify or reclassify waste at any point in time prior to disposal. Whereas under RCRA, the requirement to designate and assign waste codes is at the point of generation. And for tank waste that was in existence before the date of RCRA regulation at Hanford went into effect, the point of generation is that effective date. So that would be in 1987. And the same is true with LDR standards. They attach at the waste point of generation when you identify the waste codes, or if the waste was already in existence when the treatment standard was promulgated, then it attaches on the effective date of that rule. So in this case, that rule was promulgated in 1990. So that's when the HLVIT standard attached. Where we come into a complication, and not necessarily a conflict, but a complication in applying both RCRA and AEA, is that when energy makes its WIR determination under its Atomic Energy Authority and pursuant to its internal orders, that's an AEA decision. It's not a RCRA decision. And the state doesn't have authority over it because we don't have a decision-making role under the AEA. But the same is true on the flip side. Energy has no statutory role under RCRA. It has no decision-making authority under RCRA. So when it makes a decision to reclassify nuclear waste under the AEA, that does not automatically transfer over to RCRA. They can't make a RCRA decision. But that doesn't mean that there is no way to make that decision under RCRA. There's just a separate process that they have to go through. And so there are ways to basically comply with LDRs without vitrifying the waste. We've identified a few of those, like being able to obtain a site-specific treatability variance from the disposal site. You can also seek a no migration petition from the disposal site. So both of those things would allow energy to dispose of this waste offsite in a near service landfill without running afoul of either the AEA or the LDR standards. And I don't think that this will not come into play in the WIR determination itself, but it's something for folks to be aware of, that this is another decision and process that has to be done as part of this larger process. And there is an interplay, but they don't directly connect to each other. So I'm going to leave it there for now, and happy to answer questions later.
Should I pick it up, Simone, or?
Yeah, that would be great. Thank
Okay.
you.
So hello, everyone. My name is McClure Tosch. I am the technical trustee for Yakama Nation on the Hanford Natural Resource Trustee Council, but also do a lot of work on the cleanup and the waste management and the tank waste, as well as sort of a lot of the tribal staff and employees have to work on all sorts of things just to kind of keep Yakama's interest heard and acted upon, I guess, too, as we move forward on a lot of these matters. So to give a little bit of background, so Yakama Nation's sort of homelands before their treaty with the United States covered this entire area, that's Hanford now. And so there are things at Hanford that are very, very sacred and special to Yakama that we get direction to our program from our tribal council to make efforts for trying to really eventually have the site return to the way that it was before the releases of radioactive and hazardous substances began. So that's the direction that we have. And I should note, similar to Carolyn, I'm going to be speaking on sort of the technical issues and things that were noted by our program on this, but Yakama Nation has not taken a formal position on the testbed initiative yet. So that there is no yes or no from Yakama about this at this point, but there is sort of technical things that have been noted that we have submitted to the public record. So with that sort of in the background of what we're looking at here, there was a leader and longtime manager of Yakama Nation's environmental restoration waste management program, which is the program that is focused just on Hanford. His name was Russell Jim, and he passed away a couple of years ago, but he was instrumental in sort of getting Yakama's rights recognized at all the happenings of waste management and waste disposal at Hanford. And one of the big things that was going on as Carolyn was sort of going through her presentation, there was lots of different laws and regulations cited, but the Nuclear Waste Policy Act was supposed to result in the selection of a national deep geologic repository for where we're going to put all this nasty high-level waste. And Hanford was on the list originally. There was boreholes dug and things done to evaluate using Hanford as that repository. Through Russell's work, Yakama's work, and support from a lot of our neighbors and friends and other colleagues, including the state, Hanford was taken off the list back in the 80s. And it was supposed to go to Yucca Mountain. However, recent history and sort of political games that were played during the Obama administration, Yucca Mountain is no longer being funded as a place where high-level waste could go. So Yakima is very concerned when we start seeing these things that are, as we consider, a bit of kind of sleight of hand or just sort of trying to make things a little bit easier, because we have this reality of no national deep geologic repository to turn things that might have been originally considered high level waste into something else. And we think that has a big potential to end up with more waste being buried on site. Now, this particular testbed initiative, as was described, is all focused on taking waste off-site. And one of the things that I really want to stress for the folks attending today is that, in our view, the original environmental assessment that was sent out for I think they call it the the regulatory sort of review or something, which Yakima doesn't actually have any regulatory authority under RCRA. We have other authorities that are very important, and we really appreciate DOE coordinating with us and allowing us to comment. But that environmental assessment had a very, very detailed discussion of how they were going to put this pump into the tank of SPY 101, have a screen in it to do ion exchange and take out cesium and other things you don't want in your waste form, put it into a very secure USDOT approved tote, and then transfer that to some off-site place for treatment. That was detailed. The problem with that is that that's sort of where the detail stopped. And we had a lot of discussion about, well, it's this many road miles to go to Richland's Permafix Northwest compared to going to Utah or going to Texas. And so the major determining factor for what's going to be the biggest threat to the environment was really focused on the amount of road miles between point A and point B. So point A being where you retrieve the waste, and point B where you treat the waste. And then there's actually a point C, which is where you actually dispose of the waste, which I think a lot of people have focused on Texas, but there was discussion that Utah may be a potential as well, but that's neither here nor there. So I guess what I would like to stress or just note for everyone is that In order for this to be a fair process, they need to fully evaluate and describe for the reviewer what are the differences between these facilities where the treatment would happen. Do they currently have the type of licensing that allows them to take in this waste and treat this waste? We only had time to look at the Permafix Northwest permit, and there's sort of two permits there. There's sort of this hazardous waste handling permit, and then there's also the Department of Health sort of nuclear waste permit. And when you look at those in concert, there are potentials for when this waste comes in that you would have to change the entire function of that facility during that time that waste is there. It's not really clear how long that waste would be there or stored there, or how long it takes to treat and all that kind of stuff. These are all things that could be easily answered if we had DOE or someone from the facility here, but it's not written in a way that you just look at it and understand, what's going on. And so we didn't have time to look at any of the other treatment facilities permits. And so it could be really important to understand maybe facility Y has the regulatory ability to take this stuff now compared to facility X. You'd have to get waivers on 4 parts of your permit or do this or do that. So it's really, I think, unfortunate that we're in this position right now where we're trying to evaluate something that seems to be sort of headed in a direction of it's going to happen no matter what. And there are big questions that really should just be spelled out for the reviewer. I think another thing that is really important is this discussion that Carolyn gave about this sort of HLVIT standard. And the state of Washington and the Yakama Nation don't 100% agree exactly what we point to for how the high level waste definition that was originally put in the Nuclear Waste Policy Act gets applied. And that's just something that we talk about and that sort of thing. But in general, we do on this particular item agree that this HLVIT standard exists and you need to deal with it. How you deal with it, we might differ in opinion on that, but it's not something that we want to see get pushed to the side, because it has potential to have much larger effects down the road. One of our sort of finalizing comments in our short comment set to Department of Energy was, you're talking about 2,000 gallons of waste out of this tank right now, and you have the potential to go up to, I don't remember if it was 200,000 or 300,000 gallons in the future. It's a much larger volume with much larger potential for impacts. That if we're doing this as a test, let's treat this like we were dealing with that large volume now, so we get it right the first time instead of sort of making it up as we go later on. And I guess the last thing I would say is that this is a really hard issue for technical staff at Yakama to be making recommendations to our decision makers, our tribal council, because in general, and this is just my experience working in Superfund sites all over the Columbia River, it is so much better to stop hazardous waste, radioactive waste, any sort of waste getting released to the environment and dealing with it before that happens than trying to retrieve it and clean it up and sort of make it better. It's just never the same as it was before that release happened. So this is an instance where this is being touted as a way to deal with some of this liquid waste. And that could be reducing the amount of potential liquid waste that could release to the environment. But at the same time, there are huge questions for sort of taking something that could be perceived as like a shortcut to waste management that would not be good for Yakima in the long run, because it could lead to a lot more waste being left on site in different forms than glass. So and those are just some thoughts and some opinions. And I would like to, I guess, turn it over to Nikolas to sort of give his thoughts from Hanford Challenge. But more than willing to answer questions as we get to that point. So thank you for your time.
Thanks. My name is Nikolas Peterson, and I'm the Deputy Legal Director at Hanford Challenge. So far we've heard, a little bit about the nuts and bolts of testbed initiative, the WIR process, how some of these decisions are being made, these proposals. And, first I really want to point out that Hanford Challenge has a lot of concerns related to and intertwined with the testbed initiative proposals at Hanford. We've been pretty vocal about the waste incidental to reprocessing rule at Hanford and the tanks, which we see as an unwise, shortcut to really effective cleanup at Hanford. And we do have a lot of issues with other current proposals related to grouting Hanford's tank waste or mixing concrete with high-level waste or dumping concrete in tanks and declaring victory and walking away from cleanup. And you can find more information about that, about WIR and grout on our website at hanfordchallenge.org. But for purposes of today's presentation, I'm going to be sharing a bit more about our concerns with one of the proposed offsite treatment facilities for the waste we're talking about today, Permafix Northwest, located in Richland, Washington. I'm going to share some of the findings and recommendations that came out of our investigation into Permafix in 2020. Next slide, please. Our mission at Hanford Challenge is to create a future for the Hanford Nuclear Site that secures human health and safety, advances accountability, and promotes a sustainable environmental legacy. So in line with that mission, Hanford Challenge cares about the test bed initiative proposals for a few reasons. The main premise that was kind of talked about already by McClure is that the test bed initiative is that, Hanford, it's really going to get Hanford waste out of the tanks, treated and sent off site. And, that sounds great. And Hanford Challenge is supportive of that concept for sure. But like with many things that the Department of Energy says and proposes, you really have to look at the details. This promised offsite location is still to be determined. And at least one of the potential sites, Texas, is fighting back pretty strong. And Hanford Challenge thinks that this could result in orphaned waste streams or even more grouted waste staying put at Hanford. The test bed initiative also relies heavily on off-site treatment of waste currently, and it is not clear from the proposals to Hanford Challenge how the Department of Energy will make this decision. But it looks like a location in Washington will likely be picked, and that would be Permafix. And this is a little bit in the weeds, but it's important to note that today we're talking about phase 2 of the test bed initiative, which concerns 2,000 gallons of tank waste. The next phase, or phase 3, would scale up to 300 to 500,000 gallons of tank waste liquid treatment. Next slide, please. Permafix Northwest is a commercial facility located in Richland, Washington, that mainly provides offsite treatment for some Hanford waste and some non-Hanford waste. Back in 2018, the Department of Energy proposed treating 500,000 gallons of Hanford's pre-treated high-level radioactive tank waste at Permafix Northwest. And upon hearing about this new proposal, Hanford Challenge really started, we started collecting documents, reviewing information, talking with the experts, which led to a full investigation into the treatment of Hanford's waste at Permafix for us. And after we concluded that investigation, we issued a 180-page report called Risky Business at Permafix Northwest, the inside story on Hanford's offsite radioactive treatment facility. Next slide, please. And now real quick, I'd like to show you a short 2-minute video that Hanford Challenge made about our Permafix Northwest report.
This is the Hanford site. Hanford is located in southeastern Washington state, bordering 50 miles of the Columbia River. Hanford made plutonium for bombs for 45 years. This made a huge mess. Now it is the most contaminated nuclear waste site in the Western Hemisphere and one of the largest, most expensive, and complex environmental cleanups in the world. Most of the Hanford cleanup happens on the Hanford site, but some of Hanford's waste is sent to an off-site commercial facility called Permafix Northwest. After taking a closer look, Hanford Challenge concluded that Permafix is not the safest place to treat Hanford's waste. Why? The Hanford site is isolated from people, but Permafix is not. Permafix is in a residential community less than 1 mile from a daycare center. In 2019, there were 2 fires at Permafix, neither of which were reported in the news media. According to a state inspector, one of the fires could have been catastrophic. There were accidents where workers were exposed to high amounts of radiation. In one accident, radioactive tritium spilled out of the back of a van, exposing unprotected workers who struggled to respond without protective clothing or even gloves. Permafix was even designated a significant non-complier of environmental laws from October 2018 to October 2019 by the U.S. Environmental Protection Agency. The history speaks for itself. And now with proposals to dramatically increase the waste that Permafix is treating from Hanford and sites from all over the country, the risks are just too high. Hanford waste should be treated on the Hanford site, not at Permafix Northwest. It just makes sense. With state-of-the-art workforce training, more robust and transparent regulatory oversight, and better safety systems, on-site treatment of Hanford waste is the way to go. Check out the full report on Permafix Northwest at hanfordchallenge.org.
You ever wondered what?
So as you can see from that video before the ad or something started playing, you can see that Hanford Challenge thinks there's quite a bit to be concerned about when it comes to treating dangerous waste at Permafix Northwest from Hanford. Next slide, please. These accidents, fires, exposures, and non-compliances matter because according to the EPA, in 2010, over 32,000 people lived within 5 miles of Permafix Northwest, with over 25% of that population being under the age of 18. And as we just saw in the video, a daycare center is located less than a mile away from Permafix. In the past 10 years, since 2010, the population has increased in Richland and will likely continue to increase in the future. For example, there's a new apartment complex with 288 units that will be completed any day now that is located less than 1.5 miles from Permafix Northwest. And even as the community around the facility has inched closer, the documents show that Permafix Northwest has continued to ramp up its waste treatment. At the facility, workers have suffered exposures that could have been prevented if there were better worker training and safety systems in place. In 2006, 3 workers were seriously overexposed to radiation. And after this exposure, investigators found failure to adhere to procedures and plans set forth for the project and inadequate training. And the investigators also found a pattern in which the actual cause of the exposure was compounding mistakes, errors in judgment, and complacency for the seriousness of this type of dangerous material. Unfortunately, just 3 years after this exposure incident in 2009, another serious overexposure occurred with a worker receiving a committed internal dose equivalent of 120 rem, or 2.4 times the regulatory limit. Next slide, please. During our investigation, we also found that at least 2 fires occurred at Permafix in 2019. One of the fires occurred on the evening of May 17, 2019. That evening, a thermally hot and radiologically contaminated glass monolith was placed on a wooden pallet inside the facility. The pallet caught fire and embedded the radiologically contaminated glass monolith, causing it to be scorched. According to an ecology inspector, this fire could have been catastrophic. And here's a quick blurb from the inspector's notes on the fire. The fire at Permafix Northwest could have been catastrophic, as the fire alarms were not working and hourly fire inspections were not being performed when the fire occurred. Additionally, Permafix stated there are no fire sprinkler systems installed. Since the fire alarms were not working, Permafix Northwest should have ensured that proper fire inspections were performed by facility staff, especially when thermal treatments are being conducted at the facility. So due to some of these issues like fires, exposures, and the like, Permafix has made the EPA's significant non-complier list in the past. According to the EPA, significant non-compliers are violators that have caused actual exposure or a substantial likelihood of exposure to hazardous waste, are chronic violators, or deviate substantially from the terms of a permit, order, or agreement. You know, this designation alone by the EPA as Permafix as a significant non-complier should be a red flag for Washington State, the Department of Energy, and the people who reside nearby the facility. Next slide, please. It should then probably come as no surprise that Hanford Challenge is not a huge fan of treating Hanford tank waste at Permafix Northwest. We believe that by choosing to treat waste offsite at Permafix, that the Department of Energy has really unnecessarily dumped risks onto the communities in Richland and the surrounding areas. We concluded in our report that Hanford should really be treating this waste on site and not at Permafix Northwest. At the end of the day, you know, Hanford, although not perfect, is a more suitable location for treatment because there's a higher level of transparency and accountability. You know, a lot of the accidents, exposures, and fires I talked about had never been reported in the media, and the public didn't even know about them until Hanford Challenge collected these documents and put in a report and put it out into the world. You know, Hanford is located farther away from populated areas, and Hanford has a workforce that is highly trained, qualified, and certified to do this type of dangerous work. Next slide, please. This slide just has a couple of opportunities that are coming up to take action. The Nuclear Regulatory Commission is having a meeting November 4 this week from 10 to 11 a.m. where Permafix Northwest is seeking an exemption from the NRC to triple the amount of plutonium it can handle. Some of the issues with this request beyond the issues I just talked about with Permafix Northwest, which have also been highlighted by the NRC, include lack of appropriate security at the facility to handle this waste and problems with material control. And what I mean by material control is ensuring that the plutonium the facility receives is accounted for throughout the acceptance, treatment, and then shipping process. And although this is not an official public comment period, there will be an opportunity to submit comments on this call, and even just showing up to listen is a big deal for this. You can find more information about how to attend this meeting on our website, social media, and maybe we can drop it in the comments later too. And of course, there is the upcoming Department of Energy Testbed Initiative public comment period. So please look to groups like Columbia Riverkeeper and Hanford Challenge for comment writing guides and how you can submit your official public comment. These public comments really do make a difference, and you really make a difference. So thanks so much for your time, and I'll turn it back to Simone for some questions. Thank you.
Awesome. Well, thank you, Caroline, McClure, and Nikolas. This is going to be really helpful for the upcoming important public comment period, which we will be sending out emails to folks who RSVP'd, providing the opportunities to take action. And like Nikolas said, more information on that comment period when it does open, which it's looking like it'll open soon. So stay tuned. So we did receive lots of questions during the presentations, which we will try to get through them all. So the first one, it looks like a question about the regs. And so Caroline, I'm guessing this is to you, but what do the regs define as highly radioactive and fission products in sufficient concentrations? And if you don't know this off the top of your head, we could also send a follow-up email as well. So.
But essentially it's just the Nuclear Waste Policy Act definition, and then NRC does have a definition in, let me see, 10 CFR 60.2.
Awesome. Okay, so this next question is a bit more of a comment, but I think maybe some of our panelists would like to respond. So classification on the basis of active radioactivity and concentrations of radioactive elements would make much more sense than defining waste solely by its source, regardless of what it contains and how much concentration. I don't know if anyone has a response to that. And I also don't know if you all can see this in the chat as well. Sometimes it's easier to read it instead of hearing me read it to you.
Well, I can kick that off. I think, you know, to some extent our hands are tied because there's a statutory definition that is source-based. So until and unless Congress changes that, that is the framework. But that doesn't mean that it's high-level waste forever and it has to be vitrified. Like I said, there is this WIR process that's established and going forward, and there are ways to, like I said, get a treatability variance or a no migration petition under RIPRA.
I think, you know, I'll weigh in just a little bit too about that too. You know, that's not a problem. It's like, like I said, you also have to really look at the details and who gets to make that decision and what checks and balances are available on that decision maker. You know, it's one thing to say that sounds good, but you know, if it may come down to a result that a lot of people are not happy with, and then if people want to challenge that interpretation or have a check and balance on that system, then that should be included as any part of that process. Hanford challenge, thanks.
So this is a pretty complicated question that doesn't really have a simple answer, but in general, from Yakama's perspective, there are reasons why the laws were written the way that they were originally. And this is one of those items or pieces of legislation that Yakama had a lot of input into, being an effective tribe, actually having that added to the Nuclear Waste Policy Act process. And so when you talk about sort of changing things sort of post hoc from that process, like 40 years or more removed from when those, or even 40 years or more removed of when that happened, people lose the perspective of like those discussions, that testimony that was given, why there was interest in treaty rights, and how those changes to going from, well, it's not this anymore, it's this, can actually have profound impacts to communities like Yakama at the flick of a pen if people don't sort of really consider that. So this is super important and complicated, and we are continuing to involve ourselves in these discussions as they go forward.
Thank you all. All right, so to get some other folks asking questions, I'm going to skip a few. and go down to this one. So this is for Caroline again. So hasn't Washington State specifically repeated that, and I think this is a quote, ecology has been and continues to be supportive of exploring possibilities and options associated with offsite disposal of grouted low activity waste. Can you see that question in the chat? Sorry, it's pretty long.
Yeah.
Okay.
So I'm not sure where the specific quote is coming from, but I can speak generally to the fact that I think the state is supportive of tank waste going off-site for disposal. But the state also has a regulatory role that it can't just ignore. So it, part of our role under RCRA is to identify what waste codes have already attached to the waste and what LDR standards have already attached. If it goes off-site, any treatability variance or a no migration petition would be issued by the disposal site. And so it's not really appropriate for us as Washington State to take a position on that, because it's going to be ultimately another state's decision or the EPA's decision, depending on what state it's in and what authorization they have under RCRA. I don't think we would want, say, Texas speaking on our behalf. So we're not going to speak on Texas's behalf, but one thing that we do have to do on our end is ensure that we don't end up with an orphan waste form that can't be disposed of on site. And so we want to know that there will be a path for this stuff to actually get accepted at an off-site disposal site before we accumulate a whole bunch of grouted tank waste on site. Because like the last thing we want is basically to have that rejected at the end of the day, already have it grouted, and then have to, like, I don't know, pulverize it and then send it through the VIT plant. Like that would be the least efficient way possible. So I'll try to touch on a couple of other comments real quick here. We've heard arguments like there's a new point of generation in the middle of the treatment process after pre-treatment, and energy has an opportunity to redesignate the waste. That's simply inaccurate under RCRA. EPA guidance is very clear that that principle only applies at the end of the treatment train, so it can't apply during the treatment process after pre-treatment. But I think the bigger point is that that's not even necessary. We don't have to go and find all these other ways to get out of RCRA. There is a process, and we think it's viable. Frankly, we don't really understand why energy won't engage on that. We were ready to issue the research, development, and demonstration permit over 2 years ago for the Test Bed Initiative Phase 2. And we stand ready and willing to engage on identifying that path and helping that treatability variance or the no migration petition or what have you get in place so that we can all have that assurance.
Thank you. All right, so this is a question probably for Nikolas. So Permafix is permitted and overseen by Ecology and Department of Health. If Hanford Challenge is an issue with Permafix, then shouldn't they be concerned with the state's ability to permit and perform oversight on such a facility? And then this facility operates safely within its permits and licenses, though I think that your presentation and video kind of counteracts that last point. But if you want to go ahead and answer the first part.
Yeah, about concern about the state's ability. I guess we're not, there is some, I think with it at Permafix, what we saw also in our report was a little bit of, I think, and we don't know why it is, we're not trying to assign blame, but there was some issues, I think, as to between the Department of Health and Ecology sometimes with like who had authority and when and where, and that left for some like holes sometimes, and we think that led to some pretty bad results. So I guess, that was also one of our, if you go to our report, it offers some suggestions for how to, like, if work does continue at Permafix Northwest, some ways to try to counter that a bit. So thanks.
Thank you. And we will link to that report in our follow-up emails to folks if you want to check it out. So there's one last question I'll ask panelists. I know we're at 1 o'clock, but here's the last one. So why are requirements for waste treatment at Savannah River and Idaho different from Hanford? Yeah, let's take that one.
Go ahead, Nick.
I was going to be a little snarky. I was going to say because of our great senators, but you can go ahead, Caroline.
So I'm not the super expert on this, so I don't want to say anything inaccurate, but I know at least in South Carolina, their tank waste is not regulated under RCRA because the state made a decision decades ago to regulate under the Clean Water Act instead. And once you make that choice, there's a provision under RCRA that basically you handle it under the Clean Water Act instead of RCRA. We did not make that decision here in Washington State.
The only thing I would add is that also for quite a few years now, there's been sort of a moratorium on the sort of new definition of high-level waste that was finalized through that DOE NEPA process. But that moratorium went away this fiscal year, so it may be an exciting time over the next couple of years. I'm not sure, but just the other thing I would know. And then I guess one other thing was something that Yakama just generally is concerned about in the big picture of Hanford, not just the test bed initiative. It was a term that Carolyn brought up about orphan waste forms, and it sort of cuts both ways. You don't want to make waste forms that have no place to go, but at the same time, you don't want to not do the greatest treatment possible because you're afraid you're going to make waste forms that can't go somewhere. And that's how we sort of see the high level waste problem, is that if we can, we feel like the DOE thought process is, if we can reclassify this to be not high level waste, then we can deal with it, rather than, well, this really should be high level waste, but we need Congress to really act on this National Deep Geologic Repository issue. So it's sort of like a different take on it than, I feel like if you're the regulator, you have a lot of pressure on like, what do you do with this stuff once you make it, if there is no deep geologic repository. So just another thought.
Great. Well, thank you all once again for sharing your expertise and answering questions and your thoughts. And I hope folks who tuned into this webinar are interested in commenting when the comment period opens and learning more on this really complex but important issue. I also wanted to give a shout out and say thank you to Karina from Columbia Riverkeeper for running a flawless tech on this webinar. And for folks in the chat who want to have a copy of this webinar, we will be sending out a link. It will be posted on YouTube. So if you want to read some of those slides more closely, they will be available to you. So thank you everyone so much, and have a great rest of your day and week.
Thank you.